with me, and let's flip back to Jean, okay? And then also we'll touch on the $10 million that the suspended Chief Justice is asking for, the specific context in which she's asking for that amount from the state. But the G is essentially questioning the jurisdiction or the power of this ECOWAS Court to hear this case. And this is where I bring in Kwaku Ansah Asare. He spoke to us earlier, indicating his position on whether or not the ECOWAS Court has the jurisdiction to hear this case and whether the suspended Chief Justice has exhausted the internal mechanisms of redress before taking her matter to the ECOWAS Court. And Kwaku Ansah Asare is a former director of the Ghana School of Law. He is also a private practitioner, a legal practitioner, and also the owner of Mount Crest School of Law, essentially. But let's hear from him on this matter of the jurisdiction of the ECOWAS Court to hear this case. What's the contention in there?
Well, she exhausting internal remedies simply means ensuring that the proceedings have terminated to completion. They have, gone through every step. You see, she is preventing the steps from being implemented. So she hasn't exhausted. She cannot be said or cannot be argued that she has thereby exhausted, the internal remedies. No. So merely, inundating the court with, incessant applications is no meaningful reason to suggest that she has, exhausted the internal remedies. She has been filing application upon application, and if you look at the nature of the application that have so far been judicially considered by the High Court and the Supreme Court, you see that they were wholly, factually, and legally unmeritorious. And if an application is without any merit, the obvious outcome is a dismissal. It will be refused, and they have been refused. And when she launched the first one, you recall that on one of your shows, I indicated that she can file millions of applications, but insofar as Article 146 is concerned, the provisions stand guard over any such application. So you may file repeated applications. They can only create ugly noises in the courtroom, but applications ultimately become a social nuisance. Legally, they are incompetent. And for a Chief Justice, bringing application upon application and being told to their face that the applications lack merit is not good for her own image. It is not good, for the general public. It is not good for Ghana as a nation. That our Chief Justice will file an application that a committee, will assess, evaluate, and say it's incompetent.
I see. And that's Kwaku Ansah Asare. And I'm going to come back on how he sees this case playing out, because it has been adjourned to a date yet to be determined, and then we'll get into the details of it. But one of the issues that stuck out when this matter became public earlier today is the suspended Chief Justice demand of $10 million compensation. In what context exactly is he asking for that? Why is he asking for this money?
Well, so that is one of the reliefs that she's seeking under the substantive case. And she's seeking that amount as compensation for what she says it's an illegal suspension and investigation. So what she's basically saying that for all that you have taken me through, in my view, it is illegal. So in order to make up, at least, for what you have taken me through, which ought not to have happened, I deserve an amount of $10 million to be able to restore me to wherever I was. And that's the context in which she puts it. It's one of the reliefs she's seeking under the substantive matter.
So just a compensation for moral and reputational damages.
Yes, suffered as a result of, so when you look at the exact text, so she refers to the suspension as illegal, and then she adds investigation to it. So essentially, what she's saying is that this is how much it will take to compensate me for what you have taken me through, which in my view, it's illegal. So if the court reaches the conclusion that indeed what she's been taken through is illegal and agrees with her that this is how much she would require to be compensated enough, then well, bingo.
$10 million.
Yes.
See, but because I mean, how does he see this case playing out at the ECOWAS Court? That's another question that we sought an answer from him on. This is what he had to say.
Oh, it's one of those, cases, I think, that be a return match. They will ask her, they'll bounce her to come back to Ghana. I don't see how the ECOWAS Court can change our rules of procedure. Our rules of procedure are, firmly embedded in the High Court rules with the support of, the Evidence Act of 1975 and RCD 323. They are there. It is a procedure for Ghana. It is not the procedure for ECOWAS. It's for Ghana. And ECOWAS doesn't have, a West African sub-regional procedure that we are applying and violating. It is our own rules of procedure and evidence that we are applying. And therefore, taking the matter out of the purview of our court to the ECOWAS court is not going to achieve the desired, purpose. I think it will be defeated. And at the end of the day, I think that upon a sober reflection, the Chief Justice will realize that, she has shot herself wrongly in the foot. No one else. She's making her bed and she's lying in it. And it saddens and pains me that, she's adding more insults to injury. I've said elsewhere that she is not respecting the constitutional arrangements pertaining to the CJ removal process outlined in Article 146. She has to respect, and uphold the very laws that are administered in the courts over which she is the chief judge.
So we'll see how this case will play out at the ECOWAS Court, but Dennis Wadam Esquire giving us that very important breakdown and the details. So we all follow every step of the way, how things played out in court. That's the ECOWAS Court earlier today. Very interesting detail. And stay with us here on Ghana Tonight, because the coming days we're keeping an eye on it and we'll keep updating you on also the position and the case, the position that the Attorney General advanced on behalf of the state on this matter. But that's it for